Hello friends, this video we are recording for sharing one very important provision of the law. Friends, abhi very recently what is happening is we are receiving lot of notices in ASMT 10 and all those notices say that there is a difference in GSTR 2A and your 3B or GSTR 1 and GSTR 3B. These are the issues which is being generated, raised और ASMT 10 निकाल के then they issue DRC 01 capital A and then DRC 1 and then DRC 7. So this has been a very regular phenomena so far as GST is concerned. अब फ्रेंड्स प्रोविजंस ऑफ लॉ में सेक्शन 73, 74 बोलता है कि आपको शोकोज नोटिस इशू करना है और शोकोज नोटिस को एडजुडिकेट करना है. बट सेक्शन 75 जो जनरल प्रिंसिपल्स की बात करता है वहां पे सब सेक्शन 4 है which is very very relevant and it is to be read into two parts. One is then opportunity of being heard must be given when it is asked for. So जब हम ऑनलाइन जब हमारे पास फॉर्म आता है उसकी जब हम रिप्लाई फाइल करते हैं तो देयर इज एन ऑप्शन गिवन दैट वेदर यू आर आस्किंग फॉर द हियरिंग अपॉर्चुनिटी एंड वी click on yes or no. So that is one. And the second limb of this provision, that is 75(4), is that whenever any adverse decision has to be taken against the taxpayer, then providing the opportunity, whether asked for or not, then providing the opportunity becomes compulsory. So इसी पॉइंट पे 75 सबसेक्शन 4 पे एक जजमेंट है ऑनरेबल गुजरात हाई कोर्ट का, रिसेंट जजमेंट ऑफ 23 जून 2022 in special civil application number 11332 of 2022 and 11335 of 2022. Graziano Transmissioni India Private Limited. This is the name of the judgment. It is Graziano Transmission India Private Limited. In this case, the same was the situation. The person was exporter. He was exporting under LUT, correctly shown in GSTR 1 in the right way, in the right column, but unfortunately in GSTR 3B it was shown in a wrong column. He received notice, he tried to explain, he has reverted back to that, and all of a sudden on 25th of March 2022 the order was passed by the authorities, and therefore the petitioner felt aggrieved with this order, that the order was without affording any opportunity of being heard, and therefore it was in violation of the principles of natural justice. Now the question came whether such kind of writs are maintainable or not. So there are plethora of judgments which says that yes, it is maintainable provided any of these situations arises, and one of those situations is if the order is issued in violation of principle of natural justice. But again friends, एक चीज मैं और बोलना चाहूंगा बहुत स्ट्रांगली कि प्रिंसिपल ऑफ नेचुरल जस्टिस का वायलेशन एक पार्ट है, लेकिन एक अथॉरिटी जो एक एक्ट को कंप्लाई कर रही है, जैसे एक टैक्स पेयर कंप्लाई कर रहा है वैसे एक अथॉरिटी भी कंप्लाई कर रही है. ही इज यूजिंग हिज पावर्स and at the same time he is responsible and dutiable for whatever actions he is taking. So अगर एक प्रोविजन है जो स्पेसिफिकली बोलता है सेक्शन 75(4) कि आपको अपॉर्चुनिटी देनी है अगर आप कोई एडवर्स डिसीजन ले रहे हैं, तो अगर मैंने टैक्स पेयर ने ऑनलाइन क्लिक यस पे किया या नहीं किया, अपॉर्चुनिटी चाहिए या नहीं चाहिए, दो लिम्स है. एक कि वो मांगता है तो देनी पड़ेगी, दूसरा वो नहीं मांगता लेकिन अगर आपको एडवर्स डिसीजन लेना है तो देना पड़ेगा अपॉर्चुनिटी. सो मेरा ऐसा मानना है कि इट इज एब्सोल्यूट इन वायोलेशन ऑफ द प्रोविजंस ऑफ द जीएसटी एक्ट. वायोलेशन ऑफ नेचुरल जस्टिस को जस्टिफाई करना या उसके पास जाने की मुझे जरूरत ही नहीं है, बिकॉज इट इज इन ग्रॉस वायोलेशन ऑफ द प्रोविजन of section 75 subsection 4. For the benefit of you all, I am just trying to once again reiterate and read the provision of subsection 4 of section 75. How does it read and what are the two limbs as per me? 1. An opportunity of hearing shall be granted where a request is received in writing from the person chargeable with tax or penalty. So जब आप रिप्लाई करते हैं तो उसके अंदर आप यस टिक कर देते हैं, दैट इज यू हैव रिक्वेस्टेड इन राइटिंग. और where any adverse decision is contemplated against such person. So in or also, if you are contemplating, if you are about to issue an order which is going to be against me, against the taxpayer, then also the opportunity of hearing shall be granted. So it is not a case that he has an option. It shall be granted where any adverse decision is contemplated against such person. So friends, this was appreciated. These submissions were appreciated by the Honorable Gujarat High Court. And the order which was issued on 25th of March 2022 in this case, without affording the opportunity of being heard, was quashed. And then it was remanded back to the original authority in the books of the statutory the authorities, with the direction that now you give the opportunity, आप प्रॉपर उनको पर्सनल हियरिंग की अपॉर्चुनिटीज दें एंड देन यू कैन टेक द फाइनल कॉल वॉट एवर यू वॉन्ट. सो द सम एंड सब्सटेंस ऑफ आवर डिस्कशन फॉर टुडे इज प्रिंसिपल ऑफ नेचुरल जस्टिस इज समथिंग वेर इन इफ यू वॉन्ट टू डिसाइड एनीथिंग अगेंस्ट मी you will have to afford an opportunity, and at the same time the provision of the law is also provided in such a manner that whenever there is an adjudication process going on, and if I have asked for the hearing to be given to me, it has to be given, it is mandate. And on the contrary, if I have not asked but you are contemplating a decision which is going to be against me or adverse decision, then you are also required under the provisions of law to provide me an opportunity. So my submission would be that this is in gross violation of the provisions of section 75 subsection 4, and therefore the Honorable Gujarat High Court in this case has quashed the order. And obviously आप पूछेंगे कि quash से क्या होता है, because it will again go back to the file of the original authority, और हो सकता है वही order को दोबारा repeat कर दे. But important is whatever submissions I am making before the authorities, those should be properly recorded in the order, and then the order has to be a reasoned order. So therefore may it be a case कि वो वापस से हमारे अगेंस्ट में डिसीजन ले लेगा या यही ऑर्डर को दोबारा से वो रिप्रोड्यूस कर देगा अपॉर्चुनिटी देने के बाद, बट दैट इज नॉट समथिंग टू फेयर अबाउट. द इम्पॉर्टेंट इज यू हैव अ राइट ऑफ being afforded an opportunity of being heard, and if that is being violated, the order is certainly challengeable under Article 226 of the Constitution of India, and therefore the writ is maintainable and the order is liable to be quashed. And then it will go back to the original file of the original authority, and then you will have to make your submissions good and get the order whether in your favor or against. But once it becomes an order complying with the provisions of natural justice, complying with the provisions of 75(4), a reasoned order and a detailed one with the reasons and everything, then in that case you have alternate remedy which is available to you. So this is a wonderful judgment and I wanted to share this judgment with all of you, because आजकल ये बहुत रेगुलरली हो रहा है कि आपको अपॉर्चुनिटी देते नहीं हैं, एक नोटिस इशू करते हैं और डायरेक्ट वो ऑर्डर पास कर देते हैं. सो सच काइंड ऑफ ऑर्डर्स आर लायबल टू बी क्वैश्ड एंड सेट असाइड, and this has been done by Honorable Gujarat High Court in case of Graziano Transmissioni India Private Limited in special civil application number 11332 of 2022 and 11335 of 2022. With this, friends, I hope that this video will prove to be helpful to many of the persons who are watching it. Thanks for patience listening, and I wish and I will share few more videos with some value in the times to come. Thank you, friends. Thank you very much.